Welcome Effectors Harmony followers and welcome to this week's case law review. Today we'll be looking at AFGRI animal feeds versus NUMSA and others that was decided on in June 2024, fairly recently. This case law deals with the question of can trade unions organize and or represent employees at dispute resolution forums like the CCMA, the Bargain Council or the Labour Court if their members are falling outside the scope of their constitution. Now, for those of you who may not know, an employee in terms of Section 4 of the Labour Relations Act that deals with freedom of association, they have the right to join a trade union and become a member of the trade union subject to that union's constitution. Now, in Section 95 of the Labour Relations Act deals with the registration of trade unions and employers' organization with the Department of Labour. And one of the key elements that a trade union in this case must demonstrate in terms of Section 95(5)(b) are the prescribed qualifications for and admission to membership. With other words, in the scope of a constitution of a trade union and employers' organizations, it must demonstrate in which industries that trade union intends on collectively bargain and organize in. So this is part of the prescribed qualifications of how do you join this union. And now, as we already stated that in Section 4 of the Labour Relations Act, an employee can only join the trade union subject to the constitution of the union. So now what's happening practically in dispute resolution forums, for instance, is that unions will pitch up and represent employees maybe at the CCMA in arbitration or bargaining councils or deal with labour court applications. But the members of the union does not necessarily falls within the registered scope of that trade union. Now, this has been a contentious issue that's been going through the courts in the AFGRI animal feeds case for a couple of years now. This matter went to the Labour Court. In the Labour Court, the court found that at the end of the day, a union can only organize or represent members within territories that falls under the scope of their constitution. So if their scope does not allow them to organize in a certain industry, then they cannot organize for collective bargaining purposes or for representation at the CCMA, bargaining councils or labour court purposes, because they have to be subjected to their own constitution and they are actually limited to the authority that's prescribed in their constitution. But now where the contentious issue is coming from is that in terms of Section 161, 1C of the Labour Relations Act that actually deals with representation before the Labour Court, it actually provides that in any proceeding before the Labour Court, a party to the proceedings may appear in person or be represented, among others, by any office bearer or official of that party's trade union or registered trade union. So now the question arises, but listen, this does not speak about the scope of the constitution of the trade union. The Labour Court was of the view that at the end of the day, you are still subject to and bound by your constitution and the scope. But that decision was eventually overturned by the Labour Appeal Court, which basically said, but no, hold on. An employee, in terms of Section 161, has the right to elect their own representatives in terms of dispute resolution. And this is also supported by Section 200 of the Labour Relations Act that deals with representation of employees and employers. A registered trade union or registered employers organization may act in any one or more of the following capacities in a dispute to which any of its members is a part of. A, its own interest. B, on behalf of any of its members or in the interest of any of its members. So when you look at Section 161 and Section 200 of the Labour Relations Act, it basically creates the impression that all that is required is on an employee to be a member of a trade union and for them to elect their representatives. So from that perspective, NUMSA argued they do have locus standi to actually represent their members in arbitration and labour court proceedings, even though they agreed that in terms of Louisville, and also in terms of McDonald Transport, that they cannot collectively bargain and seek organizational rights. So finally this matter appeared before the Constitutional Court that finally raised this matter to bed. The Constitutional Court supported their previous ruling in Louisville packaging, and they actually stated, but listen, hold on, this is actually very simple. You cannot have an employee join a union and be a member only for certain benefits and only enjoy certain benefits. You can't say a member of a union can't enjoy benefits of the union collectively bargaining on their behalf with the employers, but they can represent them at the labor court. That doesn't make sense. At the end of the day, a union cannot exceed their powers. They cannot operate outside the scope of their powers. They are limited to the scope of their own constitution. And that's why Section 4 of the Labour Relations Act stated that, yes, an employee has the freedom of association and can join a trade union, but they are subject to the constitution of that trade union. Meaning at the end of the day that you cannot have a member as a trade union, you cannot seek membership of employees that are operating in industries that are not provided for and prescribed for in the scope of your constitution. Therefore, you cannot collectively bargain in industries that is not provided for or does not fall within the limitations of the scope of your constitution. And secondly, therefore, you cannot also represent employees if your scope does not apply for it. And the Constitutional Court went further to say that this has got nothing to do with the matter of justice. This is a matter of a union simply not being able to operate outside the scope of its constitution. So, obviously this was a landmark ruling for trade unions, for instance. Many companies actually do have trade unions operating within their workplace, and it will be wise and advisable for employers to ask a copy of the Constitution, which should be readily available or made available by the union, and simply check if your employer, of your company, your industry falls within the registered scope of their Constitution. If not, they do not have the right to collectively bargain, to organize, or to represent employees within your business. So, thank you for joining this week's case law review, and see you next time.